Hello everyone, good morning to all. Welcome to UN Digital class. Today we are going to discuss a new topic relating to business and corporate law, that is Negotiable Instrument Act, which was established in the year 1881. So what is relating to that negotiable instrument, or what is negotiable instrument, and what are the instruments coming under that, and relating to that different types of a negotiable instrument, what is the basic features and what are the basic difference between all type of a negotiable instrument, that we will discuss one by one. So the word negotiable means transferable from one person to another in return for consideration, and an instrument means a written document by which a right is created in favor of some person. Hence, negotiable instrument is a document which entitles a person to a sum of money and which is transferable from one person to another. So negotiable instrument is divided into two parts. One is negotiable, second one is instrument. The word negotiable and instrument having different meaning. So negotiable means transferable from one person to another for certain person or certain purpose, and a instrument means a written document in which certain purpose is taken into consideration, and when that purpose is fulfilled, that is ultimately taken the final step. So negotiable instrument is defined under section 1881. As per Negotiable Instrument Act 1881, the word negotiable instrument means a written document by which transfer from one person to another for certain purpose, and that purpose when it is fulfilled, then the person from whom that is transferred to the other for that fulfillment of the purpose. So negotiable instrument is a basic document that entitles a person for a certain sum of money, and that instrument is freely transferable without any restriction, that is freely transferable from one person to another, that is for certain purpose. So what are the basic characteristics of a negotiable instrument? The first one is freely transferable. That means the property in a negotiable instrument passes from one person to another by delivery. So freely transferable means the instrument or the negotiable instrument is a written document, and that is taken into consideration for certain purpose. So that property is freely transferable from one person to another, and that is known as transferable by delivery. Second one is consideration. Every negotiable instrument is presumed to have been made, drawn, accepted, negotiated or transferred for certain purpose or for some consideration. So consideration we already described, that giving something and getting something. So when one transaction is made, in that case, and that is in terms of money, but that money is not paid, that is paid in the form of money, that means by way of one instrument which is called as negotiable instrument. So that negotiable instrument has been made or drawn or negotiated for certain purpose or for certain consideration. That means when one person purchases some goods for certain amount, and in return, instead of paying money, he draws a bill or he draws one type of a promissory note or any other type of a negotiable instrument. That means that signifies that that instrument is freely transferable, and that is taken into consideration for transfer by way of money or in the form of money. The third one is debt. Every negotiable instrument bearing debt is presumed to have been made or drawn on such debt. So debt is mentioned in the negotiable instrument, or whether it is a kind of a bill of exchange, or it is a kind of a promissory note, or it is a kind of a check, whatever may be different forms of a negotiable instrument. All type of a negotiable instrument, in every type of a negotiable instrument, the debt must be mentioned, and the debt signifies that once debt has been mentioned, it is presumed that, or it has been taken into consideration that bearing that debt, and on that particular debt, then instrument has been drawn. The next one is recovery. The holder in due course can sue upon a negotiable instrument in his own name for the recovery of the amount. So that means when a negotiable instrument is transferred from one person to another, in that case that is for certain purpose or that is for certain consideration, and to whom that is transferred, then that person is called as holder in due course, and that person can sue that instrument in his own name for the recovery of the said amount for which the transaction has been made or the instrument has been taken by that particular person. Then the next point is time of acceptance. when a bill of exchange has been accepted, it is presumed that it was accepted with a reasonable time of its date and before its maturity. So there must be a time, and within that particular time or before its maturity that can be accepted. And in case of a bill of exchange, that is one type of a negotiable instrument. When it has been accepted, it is presumed that that was accepted within a reasonable time and before the date of maturity that must have been accepted. And the next one is time of transfer. Every transfer of a negotiable instrument is presumed to have been made before its maturity. So there is a time limit. Within that period, the instrument must be taken into consideration. Once that time period is expired or that is over, then that negotiable instrument is not taken into force, or that cannot be changed into in the form of money. So there is a time limit. So before its maturity, the person to whom the instrument has been transferred can be deposited and take back the money. So there are different types of a negotiable instrument. Basically, three types of a negotiable instrument are generally taken into consideration, and these are: one is your promissory note, second one is bill of exchange, third one is check. So one by one we will discuss that promissory note, bill of exchange and a check. So first we are going to discuss relating to promissory note. What is that promissory note, and who are the person relating to promissory note, what is the basic characteristics, and the specimen of the promissory note. So first we take into consideration the definition of a promissory note as per Negotiable Instrument Act 1881. So section 4 of the Negotiable Instrument Act defines promissory note as: a promissory note is an instrument in writing, and that must be not a bank note or a currency note, and that instrument in writing containing an unconditional undertaking signed by the maker to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. So section 4 defines negotiable instrument as, and that is relating to promissory note. So promissory note is defined under section 4 of the Negotiable Instrument Act, and it is mentioned that a promissory note means an instrument must be in a writing. So all type of a negotiable instrument, whether may be promissory note or may be bill of exchange or may be a check, that must be in writing, and that is not a bank note or a currency note, that is must be in a specified form as per the act specified. So the promissory note must be in writing containing an unconditional order, and that must be signed by a person to a certain person in favor of a certain sum of money. So the person who makes the promissory note and promises to pay is called the maker, and the person to whom the payment is made is called as a payee. So there are two persons, one is called as the maker, second one is payee. So maker means the person who makes the promissory note, or the person who promises to pay is called as maker, and the person to whom the payment is made or to whom or whose favor the note is drawn or the promissory note is drawn, that person is called as a payee. So maker and payee are two part of the promissory note, or two parties involved in the promissory note. This is a specimen of a promissory note. So on the left side the amount is mentioned, right side the place and the date that is mentioned, then that is some unconditional order that must be in written form. That means 3 months after date I promise to pay some or order the sum of 1000 rupees for value received. This is an unconditional order that must be mentioned in the promissory note. Then on the ending part, that is to whom the promissory note is drawn, then the stamp or the signature that must have been mentioned. So this is one type of a specimen of a promissory note that must be taken into consideration when any type of a transaction is made by one person against another person. Then next, what are the basic essential elements of a promissory note? The first one is writing. The instrument must be in written or writing. Writing includes print and typewriting, and may also be in pen or in ink. So written means all type of a negotiable instrument must be in written form. So promissory note must be in writing. So writing means that must be in printed form, or that must be in general pen or in general ink. The second one is promise to pay. the instrument must contain an express promise to pay. The following instrument signed by A is not a promissory note. We already discussed on the definition of the promissory note that instrument must be in writing and that must contain an unconditional order or unconditional promise to pay. So there must be a promise to pay, but in certain cases that is not taken into consideration. The example is, I am bound to pay the sum of rupees 500 which I received from you. So it is that condition, I am bound to pay, so that not mentioned in the promissory note. If this type of word is mentioned in the promissory note, then that is not called as a promissory note, or a promissory note is not mentioned this type of a conditional order or conditional promise. So all type of a promissory note must contain an unconditional order or unconditional promise. Then next one is definite and unconditional. The promise to pay must be definite and unconditional. That means the promissory note, when it is drawn or it is made, so that must be definite because that is made for certain purpose or for certain transaction, and that must be unconditional. There is no such type of any condition is mentioned in the promissory note when it is drawn or it is made by one person against another. If it is conditional or it is uncertain, then the instrument is invalid. So conditional promise or uncertain promise is not taken into consideration as a promissory note as per the Negotiable Instrument Act. So there is one example, in that case that is not considered as a promissory note. That means I promise to pay B rupees 500 when he delivers the goods. That means this is the condition, when he delivers the goods. This is mentioned on the condition. This type of a condition is not mentioned at the time of raising a promissory note by one person against another person. So when it is made this type of a condition that when he delivers the goods or when certain purpose is fulfilled, in this type of a condition when it is mentioned, that is not called as a valid promissory note, that is invalid. Then the next essential is signed by the maker. The instrument must be in written and must be signature. That means it must have been signed by the maker, otherwise it is incomplete or it is having no effect. Then certain parties, the parties must involved in the promissory note must be certain. The instrument must point out with certainty as to who is the maker and who is the payee, who the maker is and who the payee is. The maker and payee, these two parties must be involved in the promissory note. So there must be certain parties. Where the maker and payee cannot be identified with certainty with the instrument itself, the instrument, even if contain an unconditional promise to pay, is not a promissory note. So if the parties are not mentioned in the promissory note, that means the maker and payee is not mentioned. Who is the maker, who is the payee, that is not mentioned. Even if it is made on unconditional promise or unconditional order, that is not taken as a valid promissory note. So the parties must be mentioned in the promissory note and it must be in written form, it must be in signature. Then certain sum of money, that is another essential element. The sum payable must be certain and must not be capable of a contingent addition or a subtraction. This is another important point, that is contingent addition or a subtraction, that is not mentioned. If that is that, or if that type of a capable of contingent addition or subtraction, then that is not called as a promissory note. And the sum payable must be certain sum. That means if 1000 of a transaction is made, so clear 1000 rupees has been made or mentioned. If 800 is there and balance 200, if that type of a word is there, that is not called as a promissory note or a valid promissory note. So there is one example, I promise to pay B rupees 1000 and all other sums due to him. So 1000 is one sum and all other sum, that means there is another certain amount of money is there, but that is not mentioned. You must have to mention total amount 1000 or anything else if there is there. The total amount must be added and total sum must be mentioned. 1000 and other sum or balance sum, that type of word is not mentioned in the promissory note. If that is made, then that is not a valid promissory note. Then the next point is promise to pay money only. So promissory note is one type of a negotiable instrument. That means that instrument is converted into money for fulfilling certain purpose or a certain restriction or guidelines. So that is converted into money. That means the promise to pay only money or money. the payment to be made under the instrument must be in legal tender of money in India. If the instrument contains a promise to pay something in addition to money, it cannot be a promissory note. Only money is mentioned. If any addition to money is mentioned, then that is not called as a valid promissory note. So there is one example. I promise to pay B 20 shares and 10 bonds. So this is not converted into money. The value of 20 shares and the value of 10 bonds, the total must be added and the total amount must be mentioned. And if that is not mentioned, this is not called as a valid promissory note. So when it is mentioned that I promise to pay B 20 shares and 10 bonds of XY Limited, that is not called as a valid promissory note, because there is no such of a monetary form is mentioned or money value is not mentioned. So this is not a valid document or valid promissory note. Then the another one is, it may be payable on demand or after a definite period of time. So there must be a certain definite period, and within that period the promissory note must have been made or due. So it must be definite period or before the period, that must be taken into consideration. If the time is expired, then that is not taken into consideration or that is not taken into force, that is invalid. The second part of negotiable instrument, that is bill of exchange. So what is that? This is mentioned under section 5 of the Negotiable Instrument Act 1881. A bill of exchange is an instrument in writing containing an unconditional order signed by the maker directing a certain person to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. So same as per section 4, which is mentioned under promissory note, section 5 is like that. There is no difference. So a bill of exchange means that is one type of instrument. Instrument must be in written, it must have been signed by a certain person, and it must be taken into consideration for certain purpose, and it must be mentioned in form of a money, the date must be mentioned. So all type of criteria or legal consideration must be taken into consideration in case of a bill of exchange. So bill of exchange is generally an instrument in writing containing an unconditional order signed by a certain person only to or for the purpose of a certain sum of money, and that must be taken into legal consideration. So who are the parties to a bill of exchange? One is a drawer, second one is a drawee, and third one is payee. These are the three parties involved in the bill of exchange. So who is drawer? The person who gives the order to pay or who makes the bill is called as the drawer. So generally drawer is the maker of the bill, or the person who order to pay, that is called as the person drawer. Second one is a drawee. The person who is directed to pay is called as a drawee. When the drawee accepts the bill, he is called as the acceptor. That means to whom the bill is directed to pay. So that means the person who accepts the bill is called as a drawee, or he is also otherwise called as a acceptor. The third one is payee. The person to whom the payment is to be made is called as the payee. That means payee is the person to whom the amount or the payment is made. So the drawer or the payee who is in the possession of the bill is called as the holder. Drawer and payee may be the same person, and they are called as the holder of the bill. The holder must present the bill to the drawee for its acceptance. So the bill must have been presented in front of the drawee for acceptance. That means the holder of the bill must have been present that bill to the drawee for immediate acceptance. When the holder endorses the bill or note or check, he is called as the endorser. In certain cases, the holder endorses that bill to other, and he is called as the endorser. Either that bill or maybe a promissory note or maybe a check. The person to whom the bill or the note or the check is endorsed, that person is called as endorsee. So endorser and endorsee, these are the two persons. The holder who endorse the bill is called as endorser, and to whom the bill is endorsed, that person is called as endorsee. This is a specimen of a bill of exchange. The format same as per promissory note, left side the amount, right side the date and place, then unconditional order 3 months after date, pay to Ram, or order the sum of 1000 rupees, that means the amount must be certain 1000, and that is for certain value received. Then the signature and a stamp that has been taken into consideration. This is a valid bill of exchange or format of a bill of exchange. Then there are certain essentials of a bill of exchange. First, it must be in written. Second, it must contain an order to pay. Third, the order must be unconditional. Fourth, it requires three parties, drawer, drawee and payee. Fifth, the parties must be certain. All parties involved in the bill of exchange, drawer, drawee and payee must be certain. Then next, it must be signed by the drawer and the amount must be certain. That means the sum payable, that is certain. It must contain an order to pay money and money only. There is no such order is mentioned, only money or in terms of money. And there are certain other formalities that must be taken into consideration for raising a bill of exchange. The formalities are number, date, place, consideration that usually found in an instrument. Although they are not essential in law, but a bill must be affixed with necessary stamp. Though that is not necessary, but all type of a bill of exchange must affixed with a proper stamp. Otherwise, that is not called as a valid bill of exchange. So next we discuss what is the basic difference between bill of exchange and a promissory note. There are certain points. In case promissory note, there are two parties, maker and payee, and in case of a bill of exchange, there are three parties, drawer, drawee and payee. In case promissory note, it contains an unconditional promise, but in case of a bill of exchange, that contains unconditional order. Third difference, the maker of the note is called as the debtor and he himself undertakes to pay. In case of a bill of exchange, the drawer of the bill is the creditor who directs the drawee to pay. The next difference between promissory note and bill of exchange, the liability of the maker is primary and absolute, but liability of the drawer is secondary and that is conditional. The last difference, a promissory note cannot be made payable to the maker himself, but a bill of exchange, the drawer and payee may be one and the same person. In certain cases, drawer and payee may be treated as some same persons. The last one is cheque, that is mentioned under section 6 of the Negotiable Instrument Act. A cheque is a kind of a bill of exchange drawn upon a specified banker and that must be payable on demand, and it includes electronic image or a cheque in the electronic form. So generally cheque is separate from bill of exchange and promissory note. Generally that is drawn on a specified banker. A cheque in the electronic form means cheque which contains the exact mirror image. There is an electronic image mentioned or that is affixed on the front of the cheque with a proper cheque and that is generated, written and signed in a secure system ensuring the minimum safety standard with the use of digital signature. So a cheque is the size of a bill of exchange, but it has certain additional two qualifications. That means one is it is always drawn a specified banker, that must have been drawn any type of a specified or nationalized bank, and it is always payable on demand. So a cheque always payable on demand. These two additional qualification is not mentioned in case of a bill of exchange or any promissory note, but others are remain same compared to bill of exchange and promissory note. All cheques are bill of exchange, but bill of exchange are not cheque. This is one important point. All cheque are bill of exchange, but all bills are not cheque. A cheque must have all the essential element of a bill of exchange in addition to additional two qualification, but it does not require acceptance as it is intended for immediate payment. So generally cheque is taken for immediate payment and that is always drawn a specified banker. This is a specimen of cheque. The banker is HDFC Bank, pay to certain person, right side the date and the amount is mentioned, that must be certain, then in amount must be in both words and in rupees, and finally the signature. It is a specified cheque drawn on a specified banker. Then the next one is the difference between bill of exchange and cheque. Bill of exchange, it is drawn on any person including a banker, but cheque always drawn on a banker. Second, it must be accepted before drawee to make a payment, but a cheque requires no acceptance. The third point, it may be payable on demand or after the expiry of a certain period, but cheque always payable on demand. The fourth difference, a bill is never be crossed, but cheque in certain cases may be crossed. And the last difference, a bill except in certain cases must be stamped, but a cheque does not require any type of a stamp, only requires signature. So the next one is crossing of check, the different types of check. One is open check, a check which is payable in cash across the counter of the bank is called as open check. So that means when a person takes a check into the bank and that check immediately hand over to the banker or the cash counter, then the person who is in charge of cash counter take the check and make the payment to the person who hand over that check. So this is known as open check. There is no crossed line mentioned on the check, so which is called as bearer check. When a such check is in circulation, that involves a great risk. If its holder loses it, its finder may go to the bank and get payment unless its payment has already been stopped. But this open check or a bearer check having certain disadvantages, having great risks, because once that check is misplaced, any person can take that check and go to the specified banker, deposit that check and take the money unless and until the original owner of the check blocked that check by calling a phone call to the banker. Then the second one is crossed check. A crossed check is one in which two parallel transverse lines with or without the word and co are drawn. So generally crossed check, two parallel lines are drawn on the front page and there must be a word or that does not contain a word. So that is the line with or without the word is and co. If it is mentioned, that is called as a crossed check. But two parallel transverse line must be mentioned on the left side of the check, front corner of the check. The payment of such check can be obtained only through banker, and thus crossing is a direction to the drawee banker to pay the amount of money on a crossed check generally to a banker, so that the party who obtains the payment of the check can be easily traced. So it is an advantage for compared to open check. In case of a crossed check, that is very safety. So when a person take that check to the banker, only against that specified person the check can be deposited or the amount can be credited. If the person who pays in favor of that person having sufficient amount in that particular bank, then ultimately that account debited and the person to whom the check is hand over, that account is credited. So there is no chance of a theft because two parallel lines or crossed line is mentioned. So there are different types of crossing. One is general crossing. A check is said to be crossed generally when it bears across its face in addition of the word and company or any abbreviation between two parallel transverse line with or without the word not negotiable. The two parallel transverse line that simply either with or without the word, that with negotiable or without negotiable. The not negotiable with or without, that must have been mentioned, which is under section 123 of the Negotiable Instrument Act. This is the specified form of a general crossing, either two transverse parallel line with the word and co or account pay or not negotiable. Whatever may be, this is known as general crossing. Then the second one is special crossing, where a check bears across its face in addition of the name of the banker, either with or without the word not negotiable, then the check is deemed to be crossed check, which is mentioned under section 124. So the name of the banker as well as the word with or without not negotiable. This is the specimen of special crossing. State Bank of India within the two parallel transverse line. And the second one is ANDCO, State Bank of India. Account payee, State Bank of India. Not negotiable, State Bank of India. So the banker name in every case is mentioned on the two parallel transverse line. That's why it is called as a special crossing or a restrictive crossing, because the banker is specified. State Bank of India in favor of SBI, the check can be drawn or deposited. No other bank is liable for that. So this is relating to the basic concept of Negotiable Instrument Act, either that is a case of a bill of exchange or promissory note or check. What are that? What is the basic difference between all, and what are the essential elements? What is the specific form? And the next class we will discuss the other parts, the holder and holder in due course. Thank you all. Have a good day to all of you.